Hello everyone, and welcome back to this introduction series to land law, where I am trying to make it as simple as possible. And this lecture will be on estates. So we have a closer look at the different types of estates and the implications. I apologize in advance that some of those lectures will be quite long, and the reason being that I just want to really break it down into small steps and explain everything in detail using simple language, and if that means I have to really focus on the small steps to help you really understand everything, then obviously it might take a bit longer, but hopefully it will mean that you finally get the concepts and don't have to do any other reading or reviewing your notes and spending hours trying to figure out what your textbook is trying to say. So hopefully in the long run it will actually save you a bit of time, just because this is going to have lots of examples and simpler language and everything. So we'll jump right in. Just trying to explain again what estates and interests are in really plain English so that everyone should be able to understand. So you can kind of think of land rights as either slices in time or bolt-on rights. What do I mean by that? If you have an estate, you possess the land, so it's basically in your ownership. You can have complete exclusive control over that land for a specific time period. Okay, and by contrast, an interest is just simply a right over someone else's land. You don't possess the land, it belongs to someone else, but you have a certain right over the land. So maybe you can use it in a certain way, or maybe the owner promised you that they won't use it as a business property, for example, so they won't compete with your own firm, something like that. But it's not in your possession, it belongs to someone else, but you still have a certain right over the land. There's only two kinds of estate really that can be legal, so have lots of protections that are really heavyweight, and if someone else buys the land or something, this won't really be able to change because it's so well protected by the law. Those are the freehold, or the old archaic term fee simple absolute in possession, or either the leasehold, which can also be called the term of years absolute. Everything else is either a legal interest or an equitable right, which is still protected but only in equity under the kind of rules of fairness. So let's have a look again a bit in more detail with this idea that estates can be seen as time slices where you have a possession for a specified period of time. If you have a freehold, you basically own a very, very long time slice, basically forever. You could definitely say it's just guaranteed that you'll always be able to live there, But just keep in mind that in theory, there is still one person who has superior rights, which is the king, because he is the ultimate owner. So technically, forever and always aren't really the best terms, and some professors don't really like if you use them because of this idea with the monarch being the ultimate owner. But it's as close to forever as you can possibly get in UK law. The freehold, you can think of it as an own it for good slice. Having a look at the scary phrase of fee simple absolute in possession, we break it down. So you know what is meant by that. Normally you probably won't have to use it. I think most professors and definitely most solicitors and estate agents and so on prefer the term freehold. But just ask if you want to make sure that you don't lose any marks for using an unprepared term there. So, but yeah, let's just have a look at each word and term in there. The fee is just supposed to indicate that this is something that can be inherited. So you can buy the land, maybe you have a look at property, say it, and you think, oh, that would be great. So you purchase the land, and then you can inherit, give it on your death to, I don't know, your spouse or children or anyone who will then gain the property rights. Okay, so fee just means it can be inherited. The simple also relates to that. It just means that you can pass it to any kind of heir. It's not restricted the way maybe used to be in medieval times and so on to your eldest sons. It's not like that anymore. You can decide who should be your heir, so it can be sons, daughters, can be a cousin, can be a friend, can be anything really. So there's no restrictions in law really who can get that ownership. Obviously, we have to bear in mind that children are not technically able to be owners of land, but then there will be a trust set up under statute law where it's held for them until they turn 18. But you don't really need to know that for now. Absolute means that there's no conditions on the inheritance, so you can't really say, or to the ownership, you can't give a property to someone and say, yeah, you're allowed to live in there until you become a lawyer. That wouldn't be a freehold. It can certainly be something else, like an equitable ownership, but it wouldn't be a freehold. Freehold really is for a specified time period, and that's basically for forever or as close to forever as you can possibly get. So any condition which is kind of really unclear until you become a lawyer, for example, would just clash with that kind of definition. Okay, so that's why those conditions aren't really allowed for this type of property ownership. And then in possession just simply means that you have the right to occupy the property right now, not in like later times, so you can basically just move in immediately. And just to emphasize again, freehold is as close to permanent ownership as you can possibly get. Normally the only times when the property will go back to the crown, so King George for example, or whoever might be the king at that time, or queen, that will only happen if the owner dies without any heir and no will. Okay. Right, so leasehold then is slightly different because you only earn the right to possess the land for one specific time slice. So it might be this time, it might be that time. There's different length. Everything's basically permitted as long as there's a really specified period of time that's clear, that everyone will be able to understand, where you know exactly how long you can use it. So for example 10 years, 2 months, I don't know, something like that. So you basically just borrow the space for a time. You have the permission to control and exclude others. So for example, if you are I don't know, renting a place, or you buy a property that's a leasehold, then there will be someone who has a superior right to the property than yours. But you can exclude them for this fixed period of time where you have the kind of control of the property. That's what I mean by being carved out of a bigger estate. Just think of it as some kind of sort of hierarchy where you've got the crown on top, then you've got freehold owners, then leasehold owners, then you've got maybe people who are just having a license or something like that. So there's a hierarchy. But the way it works is that people get control for a specified time period, and in that time period they can exclude even people who are higher up in the hierarchy. So again, term of years, I've already indicated that a couple of times. This includes any kind of length, a week, 6 months, 25 years, whatever. The only requirement is that it has to be a specified amount that's clear and easy to understand. And then, as I said already, it's really important to keep in mind that one kind of parcel of land can have different kinds of estates existing at the same time, like the leasehold and the freehold and all of those things. Those definitely exist at once in certain parcels of land. And then you will just have to work out this kind of hierarchy and who's got the exclusive possession at a given point in time. For leaseholds, basically there's two main types that you should know. One is the fixed term, where there's a really clear end date. That is easy to specify, even if it's really long, like 999 years. That still works as long as there's a clear end date. Or the other option is periodic terms, leases, and then roll on for a specified period of time, like every week, every month, until someone gives proper notice, and then it will just end and you have to give up the control. So for example, if you've got a car who was renting a garage for 1 month, it can be some kind of informal thing without any deed. They are just renewing it every month and see how long they like to keep up this arrangement. And then either Carl or the I don't know, landlord, any person with like high up the hierarchy can just end it with notice. The really important thing, like the magic ingredient, is that you have control of the space and can keep others out for this specific time slice. Okay? And you can even keep others out if they are high up in this kind of line of hierarchy. One thing that is a bit of an exception, it's kind of unlikely it will come up in exams because it's really rare, but just so that you've heard of it, does appear in a lot of the textbooks, is a common hold. And this concerns really blocks of flats where you've got a freehold in each unit. So maybe I have a freehold ownership in the ground floor flat, then you have the ownership of the flat in the first floor, and then someone else has the kind of apartment on top, something like that. But there will be like shared areas which will be run by some kind of owners association. So this is really just meant to make it a bit easier if you have like areas that lots of people have access to, that they rent, that they share in a way. So that might happen, for example, in like student buildings, student apartments, where each student might have ownership of a certain flat, and there will be a common area like a kitchen or a living room or something like that. So those do exist, but they are quite rare, to be honest. So that's why I said it will probably not come up in any kind of exams, just because it's more common to have different types where there's like a true ownership or something like this. Now, remember from the beginning I said that there's two different kinds of things we need to be aware of. One, the estates, is kind of time slices where you own something for a specified period of time. Interests work in a completely different way. So they are kind of bolt-on rights where you don't have possession or control really of the land itself. It's owned by another person, but your interests attach to that property. That's why we can call them like bolt-on rights. They attach to the property itself. And then normally they will stay with the land even when it's sold, and so there's some new owner taking over. So imagine you agree with the kind of original landowner that you've got a certain kind of interest in the land. I don't know, maybe you've got a right of way, maybe you agree that the owner cannot use the property for business purposes, maybe you agree that the owner cannot I don't know, build a wall so you won't have any lights anymore in your living room. You don't get to see the sun, basically, something like that. This was to bind any future purchasers potentially in like if things are done properly, even though they're not really part of the original agreement. That's because those interests are really bold on tight, and they won't disappear when the property is being sold, but it does travel and kind of come with the property and limits what the new owner can do. So examples of those kind of rights that are attached to the property itself, that can be a mortgage, it can be a lease, where someone has exclusive possession for a set period of time and just pays a rent. And then, for example, we can have an easement, like the right to use someone else's land for a certain purpose. So, for example, you can use someone else's land to get to the main road, something like that. So, a right of way could certainly be something that attaches to the property. And you might remember from last session we spoke about profits à prendre. So that will be a right to go onto the land and take something, like normally something that's like natural on the land, like, I don't know, fish from a pond or timber or any kind of, I don't know, certain plants, apples, I don't know, something like that. So those can bind the purchaser if done correctly, but that depends on different factors. So whether the new owner or purchaser is bound, we will have to look at what type of right it is. So that should be your first step, that you, if you have a problem question, you try to identify whether it's like a mortgage, a lease, an easement, a profit, because those are the ones that are able to be legal and to bind purchasers in law, whereas others can only ever be equitable, like restrictive covenants or just other beneficial interests. Once you've done that and you know what type of right it is, you should look at formalities, because legal rights usually need a deed and then registration as well at the land registry, in order to be fully protected. And if those formalities fail, maybe you've forgotten a signature, maybe you've forgotten to label the thing clearly as a deed, something like that, then legal protection will fail. You might still get protection and equity under the rules of fairness, but it will lack those heavyweight legal protections. Then another thing that might be important depending on the circumstances is whether there's notice and whether the other party was claiming to have a right in the property is actually like occupying the property, really living there, because there can be some kind of rights that are called overriding rights, which we have a look at in future lectures. But so far now, for example, if you've got a spouse or a parent or someone living in the property, that you are trying to buy, you might still be bound by that, even if they haven't officially registered that right in the land registry. And that will depend on whether you had any kind of notice of that, whether you were aware of that when you were viewing the property to buy it, for example. But that's beyond the scope of this lesson, and we look at that a bit later on. For now, just remember that if a property is of the legal kinds, one of the types that can be legal, like a lease or an easement, and it's been properly registered, it will bind any future buyers. And if not, it can still be protected in equity, but there will obviously be some kind of conditions on that as well. So just to, again to give you a list of interests in land that can be legal. So that's something you should definitely be kind of learning by heart, because you will need to know this in lots of problem questions, whether you've got your SQE assessments and you need to do the single best answer questions, you will have to know this as well. So I'm just going to give you again an overview. Easements we've talked about several times now, same as profits and prendre, so they shouldn't really be causing any issues because they're quite easy to understand, like a right of way or a right to take natural products. Then we've got rent charges, which are a bit more complicated and quite uncommon these days. They're kind of rights to receive a regular payment from the land, although that's not really something that arises from the tenancy itself. So those can only be legal if it's either forever or for a fixed term. Mortgages, I don't think I need to explain that because it's quite common knowledge. It's just a lender's kind of security over the property, where they can take something as collateral if you miss any kind of agreed payments. Then we've got statutory charges, which might be created under any kind of statute, like tax and those kind of things. Or we have rights of entry that a landlord or rent charge owner still has in the land. If you breach any of the conditions for your ownership, maybe you don't pay the amount that has been agreed, maybe you decide to use it as a business property even though you promised not to, and so then the owner higher up in the hierarchy might be able to just say, no, I'm taking ownership of the property again. In practice, the most common ones you see are the easements into mortgages, but it's good to know the other ones as well, just to be prepared for any kind of exam questions. So let's have a look at the formalities in a bit more detail. Those are obviously specified in different kinds of statute. So really, in order to give your estate or interest legal, really heavyweight, important protections, you will normally need a deed. So what is a deed actually? It has to be some kind of agreement or contract in writing. It has to say that it is an actual deed. It has to be signed and it has to be witnessed. And then there's a requirement for the deed being delivered as well, which basically just means that you intended it to have legal effect. So you might remember from like contract law, for example, that contracts are only valid if there's a legal intent. So that's quite similar here. Quite often you will have like exam questions and those kind of things where people are trying to make something legal and they are trying to create a deed to give it like those heavyweight protections, but then they make some kind of mistake. Maybe they will not have a witness there, maybe the witness forgets to sign, maybe the actual parties to the contract forget to sign, maybe they forget to say it's a deed, something like that. So in that case, it will be not a legally protected estate or interest, but it might obviously still be protected in equity. The only exception to the rule where you don't really need a deed, or where the key exception at least, that you will definitely have to know for exams is the parole lease. And these are a bit different because they're very short, less than 3 years. And in that case, you don't really need a deed. You don't even need anything in writing at all. It can be just some kind of verbal agreement that you make on the spot. But the requirement is that it's for 3 years or less. And it starts now, you get immediate exclusive possession. You are paying the best possible rent. That's like equivalent to market levels. Like if you have a look at properties in the same area, you find that you're paying roughly the same amount as other people. And it shouldn't be something where you just pay a one-off lump sum in the beginning or the end, but there has to be like periodic rent payments or something like that. Otherwise, it won't fall under that kind of exception for parole leases. Um, so, one key aspect of this is that very often, if you go on to, I don't know, one of those big housing sites where you can look at property, like, I don't know, Rightmove, Zoopla, whatever, or you contact an estate agent. Maybe you want to approach some landowner you actually know in person, and you will very likely, because this is a huge kind of sum that's being involved, lots of kind of steps you need to complete, just make a contract for the land first before you actually get to the deed stage. So in the contract you might say like, look, I want to buy the property in once I've, like, for example, sold my own house first, something like that. So you make a binding agreement where you will need obviously the key things that you know from contract law, like an offer, acceptance, consideration, and legal intent. So if you've done contract law already, you should know those key elements that are definitely required. And then at a later stage, when you've kind of sorted out any kind of issues with, I don't know, selling property with the onward chain, that kind of thing, then you will only get to the actual deeds where you transfer the legal rights. So the thing is, obviously, deeds do go wrong. There are lots of things that can happen. Like I said, people forget to sign. Maybe people forget that they need a witness. So if that happens, you might still have an equitable interest in the land as long as the first kind of contract was valid and you have completed all the key elements of that initial contract, like being in writing, like having signatures, like having consideration, those kind of things. So even if there's some kind of mess up with the deed, you might still have some kind of protection, or even if it just means that you have lots of issues and everything takes so much longer than you expected, and it's so difficult to say your current property, or during that time after the initial contract to the time you have the actual deed completed, you still have a protection in the equity. So yeah, that's just for potential purchasers to have a bit of a safety net, because there's so many things that can go wrong. So the idea behind that is that equity has this rule that they will protect some kind of contract or agreement as good as done if you were really making an effort to complete the agreement, but something happened. It's not the claimant's fault. They didn't really break the deal, but it's just something's got in the way. Then equity might say, yeah, well, it's only fair that we will protect that initial contract and agreement, and just provide that little bit of a safety net. But that really depends on whether the claimant is at fault or not. So that's the kind of clean hands principle that you might have heard from equity. In Walsh versus Lonsdale, for example, the two parties made a valid contract for a 7-year lease. So some party wanted to get a lease for 7 years. They made a contract, there was payment, everything important that you need for the contract. But then there was an issue with the deed. There was no completed deed. But the courts, they said, okay, that's not the claimant's fault, so we will protect his lease as an equitable lease, because we think that's only fair in those circumstances. Okay, so really important case law here. The contrast is, for example, in the case of Coatsworth versus Johnson. There was also some kind of contract for some kind of property that they wanted to own for a certain period of time, but then it was the tenants themselves who actually breached the contract and didn't comply with one of the important terms in that contract. And so equity said, right, it's the tenant's fault. They have unclean hands, so as to say, so we're not going to protect that right, sorry. We're not going to give you an equitable lease because you've breached the contract yourself. Okay, and then another kind of important case law is in Parker versus Taswell, and this is a bit of a more curious ones, where the parties try to grant a legal lease, but the document wasn't actually a deed, and then lots of things were going a bit wrong there. But in the end, it was still protected as an equitable lease because of the initial contract, because the tenant didn't really make the mistake there, and specific performance was still available. So you might want to have a look at those bits of case law. Maybe I make a bit of an extra lecture as well on key case law precedents that you need to know for exams. I just have to see when I get the time to do those. So let's just focus a bit more on equitable interest. What does it even mean when fairness kind of steps in, even though there's not an actual legal protection? So equity covers any kind of deeds, as we've said, where you've got a contract for the purchase of a land, but maybe it just takes some time to finish the deed, or maybe there's been an issue with the deed. But at any rate, equity still provides some kind of protection in the meantime. So if you miss a formality, equity might still say, hey, look, we still protect our right. And that will obviously depend on things like the clean or unclean hands principle. Then obviously we already mentioned things that can only ever exist in equity, like the restrictive covenants, but we will discuss that in future lectures. And you might also be aware of trusts already from trust law. So far I just want to give you a brief overview of what trusts actually are, as far as it concerns land law. So on the one hand we have something called express trusts. What are express trusts? So those are trusts that are being deliberately created with the intention of having a trust. So maybe you've got an original landowner called the settler who decides, I want to give that kind of legal title away to someone else. Okay, but I can't really at the moment give that to this specific person, the beneficiary, who will in the end benefit from those kind of legal rights, but I have to take a intermediate step and give it to a trustee to hold for the time being. That all sounds really complicated, so let's just have a look at an example. So for example, we've got a dear who owns a property called Brook Mansion. So he then wants to give this property to his child Mariam. But he knows Mariam, she's just, I don't know, a toddler, for example. She cannot hold the property at the moment, she can't own it. So I will give it to someone else who then holds it on trust till Mariam is old enough to actually claim the full ownership and enjoy the full benefits of the property. So even though Mariam isn't technically the legal owner, because she can't probably until she reaches 18, she is still protected in equity. Just out of fairness. The thing for express trusts is there obviously needs to be signed and in writing and so on, otherwise it wouldn't count as an express trust that has been created on purpose. Okay. By contrast, an implied trust doesn't have this kind of formal declaration. So there's probably no writing, there's no deed, there's no signatures and witnesses. All those formalities aren't really existent in implied trusts. Instead, they arise from conduct. So equity will just have a look at how people behaved, what they did, what kind of intentions they probably had, that kind of thing. And the two main types are resulting trusts. So those happen, for example, if there's a party who buys a certain property and I don't know, a parent, a spouse, someone else helps with the purchase money. Maybe they help with the deposit, that kind of thing. Then they will have a beneficial interest that is in proportion to their actual share in the purchase money. So, for example, if Dolly buys a house and then her mum Enid pays the 10% deposit, it will mean that Enid will have about a 10% beneficial interest in that property. Okay. The other type is a constructive trust. So there are a couple of different types of constructive trusts. Again, those kind of subtypes. We will have a look at those in more detail later on in future lectures. But the main one that comes up in land law is if there's a partner who doesn't contribute initially to the deposit. Maybe they weren't even together at the time, they just met later on, that kind of thing. But they definitely made some contributions later, like they helped with the mortgage payments, maybe they helped with renovations, that kind of thing. So then equity was saying, well, it's only fair if they made all those contributions, they've put so much money and time and effort in the property, then we protect it because it's only fair to do so. Example again, let's say that Amanda owns the house and then a bit later on, her partner Daniel moves in, and for years and years he always pays half of the mortgage payments. So that means that there will be a constructive trust that gives Daniel a beneficial share even though his name doesn't show up on the original deed. So he still be protected to some extent. He not have those really heavyweight protections in law, but he still have some kind of limited protections in equity because he spent all this money and all this time to help with the property. Okay, so it's only fair that people like that are protected to some extent. Just again to keep in mind that not every kind of right in a land can be legal. There are certain ones that are always equitable by nature and can never gain those kind of heavyweight legal protections. So those are beneficial interest under a trust, restrictive covenants, which we have a look at in future lectures, and certain kinds of estate contracts, which have been binding in terms of an estate, but haven't really reached completion yet. Okay, one bit of a curious one are statutory home rights under the Family Law Act 1996. What are those? So it's a bit similar to the original example we had just seconds ago. We have a kind of spouse or civil partner who lives in the property as their kind of family home or matrimonial home, even though their name doesn't appear on the original deed. They weren't really party to those original agreements when the property was purchased. But those wills, they have the right to live in the home with their spouse or partner if certain conditions are fulfilled. So they have to be married or to be civil partners. So before any kind of divorce proceedings, and the home has to be intended to be their home, really. So that's something that might be the case even if they weren't on the original deed. There must have obviously been some point where the party said, yeah, let's move in together and we intend that you can live here and we can share this property. And it's kind of an intention on both sides that they will live together. And it hasn't necessarily got to be something that's written down or that kind of thing, but it has to be some kind of intention that can be concluded from their conduct, things they said to each other, things they did in reliance, those kind of things. The key thing here is those home rights under the Family Law Act aren't actually an interest in the land like all the ones we've discussed before. Instead, they are in addition to any kind of trust like the constructive trust or resulting trust that a person may already have in equity. They're not cancelling each other out, but both can exist at the same time, okay? So they're a separate kind of thing, and they can exist in combination together with other trusts. An example, let's say that Harriet is the owner of a freehold property. She is the one who purchased it. She's the one whose name is on the deed. but her wife Nicole paid some part of the original purchase money. So Nicole will have a resulting trust share because, as we said, that happens when there's someone who helps with the purchase money in the beginning. But also, because they are married, they're living together, it was kind of, as we can see from different things they did, intended to be their matrimonial or family home. So she will also, on top of the resulting trust, also have home rights under the Family Law Act. Okay, so those are two separate protections that Nicole will have. They're not cancelling each other out, they're both existing in combination to give Nicole extra protections. Okay, and then lastly, just another type of exception is a license. So licenses are a bit different because they are just personal permissions. What do I mean by personal permissions? Those are not things that attach to the land, they're not bolt-on rights, they are just really an agreement with a certain person that really is only for that person. So it doesn't connect to the land, it's not something that can be inherited, it's also not something that will bind future purchases because it only concerns the original parties to the agreement. Okay? There's a couple of different things that different types of license, so maybe it will help to have a look at those as examples. A bear license, for example, is something you will have encountered very often in your life. So, for example, it's a kind of permission to enter the house of a friend. Maybe they invited you over for coffee. Obviously, you don't have suddenly any rights in that property. Um, that's also not something that can be inherited or can bind a future owner. It's just kind of informal, personal permission from one friend to the other. Doesn't have any legal protections, and it can end at any time when it's withdrawn. Maybe you fall out with your friend, they will revoke the permission, and then you don't have any right anymore to enter that property. And you can get into a lot of trouble for trespassing if you continue to visit that property even though the permission has been withdrawn. Okay. Next type will be a license coupled with a grant. So that arises when someone is granted a right to take something in particular from the land. So maybe you only have a kind of permission to enter the land for certain purposes, like hunting, fishing, I don't know, cutting timber. But you can't just then go in to do something completely else, because that would not be included in the permissions of, I don't know, maybe you've got a person to that's allowed to come into your property to do the gardening, then that permission wouldn't include that they can, I don't know, come into the property and, I don't know, sleep in your bed, for example, or spend hours watching TV when you're not there, that kind of thing, okay? And then Last main type would be a contractual license, which you will obviously have encountered lots of times as well, where you purchase some kind of permission to enter the property. So, really common, you buy a ticket to a concert or a cinema. So, for that one specific time and day, you'll be allowed to visit that property. I don't know, maybe you've bought one of those tickets for Coldplay in Wembley, so you will only be able to get into the stadium for the time specified on your ticket. And it doesn't mean that you are suddenly allowed to come into Wembley Stadium whenever you want. You can certainly not go, oh, I've got that ticket for Coldplay. Now I go and see, I don't know, an England match or another concert or wherever you want. It doesn't work that way. And also, if you don't behave, maybe you're like smuggling any prohibited items, maybe you're, I don't know, causing a fight, that kind of thing, then people can still just revoke that permission and say, yeah, you've breached the contract, you're not complying with the rules, so we are taking away your permission and you won't be able to enter anymore. Yeah, so that's it. Let's just have a little quiz to wrap things up. What is an estate in land? Just think about that for a second. Alright, so estates should be those time slices that we have seen where you possess the land for a period of time. Okay. By contrast, an interest in what's that? That should be one of those bolt-on rights where you don't have possession, but you still have a certain right over the land. Okay, question number 3. Which two estates can be legal? A. Freehold and easement. B. Freehold and leasehold. And C. Leasehold and license. And the answer should be B. So really important. We've got two types of freehold and a leasehold, or obviously those fancy old arcade terms like fee simple, absolute impossession, and so on. Okay, what is a freehold then? Who remembers what that actually was? Let's have a look. I'll give you a short moment. And a freehold should be something that you can own basically forever. It's inheritable and it's not bound by any kind of conditions. By contrast, what's a leasehold? Who remembers what we said about leaseholds? They are rights to possess the property exclusively for a kind of fixed specified term or a rolling periodic term. Right then, if you got that, what is a periodic lease then? Okay, it's kind of included in the name anyway, so it rolls on from for a specific time. So maybe it's week to week, maybe month to month, until someone decides, oh, I'm handing in my notice. So if we come to an end at that point. What is a common hold? That was one of the kind of special cases, quite rare, but good to know. Who remembers what that one is? And it should be B, so freehold for flats with shared management of kind of shared areas. And just last question. Are restrictive covenants legal or equitable? Yeah, that's a bit more of a tricky one. And the answer should be A, they can only ever be equitable, but we have a look at that in future lessons in more detail. For now, well done, you've definitely made it. Really good job. I know it's a bit of a tricky topic, but I hope it helped you to just make things a bit clearer. Thank you, and see you in the next lecture.